Hi there, my name is Beverley Addison. I'm a solicitor with BTO Family Law in Glasgow, and I'm here today to demystify the top 10 myths about getting divorced in Scotland. Now there are many more than 10, but we've picked the top ones that always come up. And if you've got any other questions about divorce law, family law, child law, drop them below in the comments box and we can answer that for you. And of course, if needed, then just get in touch with us. My contact details, alongside everyone else in the teams, are just below. So let's get into it. Now, of course, coming in at number 1, the common law wife. Now, you may have heard the terms common law wife or common law spouses used quite often in American TV shows, or your friend might have told you that if you are living together for a certain number of years, then you automatically have the same rights as a spouse. Now, that's unfortunately not the case. If you're cohabiting and you live together, there are claims that you can make if that cohabitation comes to an end, but you must make sure that you consult a solicitor straight away, because you don't unfortunately have any automatic rights, and in fact you have a strict time limit of only 1 year to make an application. So if that is the case and it applies to you, then you should consult with a solicitor immediately. Number 2 on our list is that pensions don't form part of your matrimonial property for division on divorce. Now, that is a myth, because pensions do fall part of matrimonial property in Scotland, and in fact it can actually be the most valuable asset that either of you own next to your equity that's in your house. So it is important that you both get those valued and that you make sure that it's included in any division, as you not including that as part of your settlement might cost you a lot in the long run. So number 3 on the list is that I don't have to pay child maintenance if I don't see my children. In Scotland, no matter why you don't see your children, you still have an obligation to maintain them, which means paying maintenance through the Child Maintenance Service, or the CMS. Now, if you aren't seeing your children because your ex-partner won't allow you to, then you should consult with a solicitor straight away in order to obtain court orders for contact with that child. Number 4 on the list is that you can't commit adultery if you are already separated, but in Scotland that's actually not the case. Your date of separation is really important, because that's the date that all of your assets and liabilities will be valued for division on divorce. But you technically are still married, so if you do get in a relationship with someone else during that time before you're divorced, your spouse can still raise divorce based on the grounds of adultery. However, in reality, it's not worthwhile raising your action based on adultery if it can possibly be avoided, due to it being really difficult to evidence. And at number 5, and sticking with the theme of adultery, if your spouse commits adultery, you will automatically be entitled to a greater share of the matrimonial assets. Now, in Scotland that's not the case. Divorce is no fault in Scotland, and so it has no bearing on the matrimonial property to be divided at the end of the day. Number 6 is that the mother of the child will automatically get full custody of that child. Now, in Scotland that's not the case, and all care arrangements must be made in the best interests of the child. As a starting point, it is acknowledged that both parents should be in a child's life unless there are circumstances to show why that would be against the best interests of the child. There's no automatic allocation of care based on gender. And at number 7 is a related myth that parents are automatically entitled to a 50-50 share of the care of the children. Again, that's not the case. In Scotland there's a really holistic view taken about what's in the best interests of each specific child in their specific circumstances. So whilst 50-50 may be right for your family, there's no automatic entitlement to that. Now, the myth at number 8 is that gifts from third parties automatically fall into the matrimonial pot. Now, that's not the case. If you've received a gift from a third party, or in fact an inheritance, and it hasn't changed nature since you received it, that will float above the matrimonial pot and is not liable for division on divorce. However, you need to be careful about whether those assets have changed nature. For example, if you received an inheritance of cash and then you purchased a property with that, the property will fall into the matrimonial pot, but you'll have a special circumstance to argue for an unequal division at the end of the day. Now, myth at number 9 for all the grandparents out there is that you have automatic rights for contact with your grandchildren. Now, unfortunately, there is no automatic right of contact with grandchildren, but there is an ability to seek a contact order if you want to be deemed to be a relevant person of that child. It's really important that you seek independent legal advice for yourselves about the most appropriate action to make sure that you get to see them as soon as possible. And the myth closing us out for number 10 is that prenups aren't valid in Scotland. Prenuptial agreements, or prenups as they're often known, are perfectly legal in Scotland, and so if you have significant assets that you wish to ring fence or protect before marriage, then it definitely is something that you should consider. So those are our top 10 myths demystified about getting divorced in Scotland. If you have anything else that you'd like us to answer, then just drop us a comment below. I'll see you next time.